He forcefully took the gun away from the victim.
Doesn't make sense, and you've changed that story. It's not what you said initially to the police. You told them you got rid of it, you sold it. And now you say you left it there, which is completely inconsistent with your version of what happened. You wouldn't take it because you felt your life threatened and then just leave it there and walk away when the victim can just go get it and shoot it if that's what you were really worried about.
Your Honor, if it please the court, we're before the court this morning in the matter of the State of Ohio versus Terrence Gardner, case number 25 CR 1679. The defendant is present in the courtroom with his attorney, Mr. Walt Edwards. We're before the court for purposes of sentencing, the defendant having pleaded guilty and been found guilty of count 2. It's a felony of the second-degree robbery with a 1-year firearm specification. Also count 6, felony of the third degree, having weapons while under a disability. Parties are ready to go forward, Your Honor.
Thank you. All right, Mr. Edwards, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Briefly, Judge, I have been in receipt of the pre-sentence report. I believe it to be fair, accurate, and complete. No additions, deletions, or corrections. I've also received the psychological evaluation by Lisa Friend, and I would stipulate to the findings contained therein. Judge, I would thank the State of Ohio for negotiating in good faith towards what we believe is a fair and equitable resolution to this case. You know, this is an unfortunate event by someone who, notwithstanding a conviction in Cuyahoga County from last year, did not have a significant history of violence. As a child, he had just a few juvenile adjudications, none of this sort. The prior conviction out of Cuyahoga County with his father, we discussed off the record the circumstances surrounding that, and it is, I would say, not a typical situation. Here, I would respectfully submit to the court as well that this is not a typical robbery. When you think of a robbery, you think of a sort of predacious motive or profit motive-driven act. This is something that evolved very quickly. As I understand it, my client had just gotten off at work at Condado. He had met up with 2 other individuals, one of whom made arrangements to meet with the victim to secure some marijuana. The victim then ended up entering the vehicle that all 3 were in. The victim had a gun, and there is some dispute as to what happened between the victim having his gun and Mr. Gardner leaving with his gun. But what I would say is we've stipulated to a factual basis to say that there is a robbery. He forcefully took the gun away from the victim. I would ask that the court consider that, I'll call it a sort of labored acceptance of responsibility. He didn't immediately acknowledge what he did here, but he did ultimately acknowledge to the police what he did, which fits the statutory definition of robbery. But I don't think when he woke up that morning, certainly when he got in that car, he never intended to steal anything from someone by way of force. That said, he's been a pleasure to represent. We have never had a bad moment. He is very polite, very respectful. The only thing I would say, and I know I stipulated to the Friend report, but he had an IEP in school. The reason why he was referred is because I believe, just in my encounters with him, that there are some cognition issues. I'm not suggesting that that is at all an excuse for what occurred here, but I would say, looking through a broader lens contextually, that I think he has some cognitive issues. And how does that impact him? Well, it impacts his ability to navigate through stressful situations in a rational way that most people would.
Maybe marijuana attributes to that as well.
I don't disagree with you, Judge. I think, he has maybe these deficits, and then that is only compounded by the fact that he is further numbing his brain through the use of illicit substances. So the marijuana just makes it 10 times worse. But again, I would submit to the court that based on my interactions with him, he is someone worthy of the discretion of this court. He is only 19 years old. I would ask the court consider, sort of system of graduated sanctions, give him an opportunity to have a meaningful young adulthood instead of, a number at the higher end. I'm asking that the court consider a 3 or 4 year term. And here's another reason why that might be appropriate under the circumstances. he does not have, because of the structure of the plea and his prior conviction, an opportunity to petition the court for relief under the judicial release statute. He cannot earn good time. He cannot kite a social worker for transitional control. So whatever the court imposes is the term that he will do, notwithstanding, the potential for doing additional administrative.
Isn't that the way it's supposed to be?
I'm sorry.
Isn't that the way it should be or supposed to be?
Well, I don't know here.
I mean, I know.
Yeah.
Whatever. I understand. I understand what you're saying.
Yeah. The other thing, as an aside.
I mean, if that's the case, then I should keep taking into consideration when I sentence somebody that can get this breaks, to give them more time so they do the amount of time I really want them to do.
No, and I get it. I hear you, Judge. My biggest thing with all of that is like taking away good time from people, because it creates a disincentive to not engage in bad acts while you're there and engage actively in programming. So that said, again, I would thank the state of Ohio. I would thank the court for its patience, and I would respectfully submit that a sentence near and around the bottom of the range is sufficient to protect the public and punish the offender, and consistent with the purposes and principles of felony sentencing. Thank you, Judge.
Thank you. Mr. Gardner, you have the right to address this court before you're sentenced. You can say anything you want. Is there anything you'd like to say at this time?
Yes, sir.
Go ahead.
I highly regret what I did. I don't really think the act that I did was fair or right to do. In my eyes, I thought I was defending myself, but I didn't think of the eyes of the law. So I deeply regret doing what I did to my victim. I'm sorry to my victim. I hope our victim knows that I didn't mean to do it. It was just the attention and the air that I felt, and I deeply apologize for that. I'm really not a person that goes looking for trouble. I really stay back to myself, work, and I got love for my nieces and nephews. I like to be around my little ones the most I can. So I just hope and pray that today you could give me a reasonable time to do, so I don't have to spend a lot of time away from my family. I'm not saying this is a bad situation, because I can turn this situation to a good situation when I go down the road and make something out of my life and take programs. Even if it's not for good days, it's still better my health. And I can just see that and mature up in life, come out as a responsible man and and fulfill the needs of my family when I come out. That's all I take out of this.
Thank you, Judge.
Thank you. Mr. Shapiro, on behalf of the state of Ohio.
Thank you, Your Honor. As Mr. Edwards stated, this is mandatory prison by operation on the underlying offense by operation of the defendant's prior F2 conviction. I was just thinking about what the defendant said, Mr. Edwards, and I was just looking at the pre-sentence report. It shows that through the juvenile division of this court in September of 2023, the defendant was ordered to complete the court's intensive community rehabilitation program. I don't know what that is, what kind of treatment programming that entails, but it looks like there was some sort of a program here that was offered to the defendant in the relatively recent past. It was a couple of years ago. He was before Judge Shaughnessy downtown in September of 2025, September 29th actually, which is about 2 months prior to the defendant committing this offense. And inasmuch as the defendant was employed at that time, he was working at Condado Taco in Menor, he also was getting off work and smoking marijuana, which was a violation of his probation at the time. And that was right after he was in a courtroom with the judge telling him not to do that. We also have, Your Honor, detailed in the pre-sentence report a number of sanctions and behaviors of the defendant breaking the rules within the jail, which is the most structured environment we have in our society, where as much control as we can exert on someone to follow the rules is in a jail. And within those parameters, the defendant cannot conduct himself within the rules before him. And some of those were even violent encounters in the jail. And maybe that trouble came to him, like he's saying, and he had to deal with it. But there's a lot of inmates over a lot of years that the trouble doesn't come to them. So I don't know if it's a coincidence, Judge, and certainly not a coincidence the defendant took this gun and disseminated it on the street. Now, that's what he told the detectives, and it makes sense because the gun was never recovered anywhere at all, let alone right next to the car. The defendant says in his pre-sentence report, what I actually did is I got out of the car and I placed it on the ground and ran away. It defies common sense. It's not consistent with his thinking that this victim was going to use that gun against him. So I'm not sure what to think at this point in terms of what happened from his perspective. I can tell you what the victim told me, and what the victim told the police was that was not the case. Now, the victim does say that he did have that gun out in the back seat, and that the defendant did tell him, hey, put that away. I'm not saying that's not true. The victim acknowledges like that. Mr. Edwards said there were a good number of consistencies here. And that's true, up until we get to the point where there's aspiratation of the gun. Then there's differences. Either way, Judge, we have a gun with a 50-round mag, drum mag, that was disseminated on the street because of what the defendant did. So this is not, from the state's perspective, a situation where the minimum would satisfy the purposes and principles of sentencing. Based on the defendant's conduct, the fact that there was injury here as well, and I mean, we have a short history, but it's chock full of violations in a short period of time. I would ask the court to consider that and fashion a prison sentence that's commensurate with all of that. The state believes it's more of a mid-range situation. The defendant does have credit for 150, that's 150 days. I have no requests or figures about restitution to present to the court.
Thank you. This court reviewed the pre-sentence report and investigation, the psychological evaluation. I've considered the facts and circumstances of the offenses involved here, the nature of these offenses. I've considered what's been said here today by the defendant, his counsel, the prosecutor, the recommendations from everybody. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. So the factors in 2912, court finds the victim here suffered serious physical harm as a result of the conduct involved. As for the recidivism factors, the court finds many of these are present. The defendant was on probation or community control sanctions to Cuyahoga County at the time he committed this offense, and the offense that he was put on community control sanctions was for an offense of violence involving a firearm. He was put on community control on September 29th of 2025, and then 2 months later he committed this offense. He has a history of juvenile delinquency adjudications and criminal convictions as an adult. He was only 19, but he's got the prior, as I mentioned, felonious assault with a gun. He's not complied with previously imposed sanctions ordered by the court. You're on probation, and you're smoking weed, you're possessing firearms 2 months after being put on probation. Doesn't sound like somebody that wants to do what you just said you wanted to do. While in our jail, you consistently have been getting in trouble, and a lot of that trouble involves violence, fighting. And I find it hard to believe that you're always the victim in all of these, always in the position defending yourself. You don't have this many incidents incidents involving violence when that person is always the victim, is never the one instigating anything. In regards to the seriousness factors, I'm also going to note that you put a firearm with a 50-round drum into the community. Your statement that you left it on the sidewalk doesn't make sense, and you've changed that story. It's not what you said initially to the police. You told them you got rid of it, you sold it. And now you say you left it there, which is completely inconsistent with your version of what happened. You wouldn't take it because you felt your life threatened and then just leave it there and walk away when the victim can just go get it and shoot it if that's what you were really worried about. You put a gun with a 50 drum, again, magazine into the community. I don't know if drug abuse problem related to the offense, but there's certainly a drug abuse problem here. You, for the last 2.5 years, smoke an ounce of weed a day, 25 blunts a day. There's only 24 hours in a day. Assume you sleep a few hours. So you're just high all day long. 25 blunts a day. So you're smoking like a couple blunts every hour? How much is an ounce of marijuana?
Like 28 grams,
Yeah, 20 grams. A couple $100?
90.
Your work history shows that you worked for 1 month. So where'd you get the money to buy $90? And I think that's low, quite frankly, but I'll go with your figure. $90 a day. So you're spending $630 a week. What's that? $2,500 a month you're spending. $30,000 a year. Smoke marijuana every day. Where'd you get that money?
I helped my friend, dad, paint houses.
You didn't tell probation about that when they asked you about your employment history.
Because I was an employee.
Huh?
I was an employee. I was under I was never hired. It was just
You were working and getting paid, you're claiming. That's being employed. If you really did that. So you had $30,000 just to throw away every year on marijuana?
Sometimes I got it for free.
There's no factors indicating recidivism is less likely. Under 2913B, well, that's irrelevant here. There's a mandatory prison term. The court finds there's a mandatory prison term. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to available community control sanctions. Therefore, it'll be the sentence of this court on count 2. Defendants serve a mandatory indefinite prison term of a minimum of 4 years, maximum of 6 years. Count 6, he served a prison term of 18 months. That'll run concurrent to count 2. Both of those terms, however, shall be preceded by a 1-year mandatory prison term for the firearm specification, which again shall be served prior to and consecutive to the prison terms imposed in counts 2 and 6 for an overall mandatory prison term of a minimum of 5 years, maximum of 7 years. There's 150 days of credit which the defendant will be granted. Need to advise you upon your release from prison, you will be placed on post-release control for at least 18 months, up to possibly 3 years. If you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Defendants award the penal cost incurred in this action. The balance of the indictment will be dismissed as agreed to, as well as any other specifications. The court further hereby advises you that there is a rebuttable presumption that you will be released after you've served the minimum sentence, which is 5 years. Now that's not guaranteed, but there is a presumption that that will happen. However, that presumption could be rebutted, means overcome by the prison officials if it's found during a hearing that you'd be entitled to have if they don't want to let you out after the minimum. That while you were in prison, you violated the institution rules. You committed infractions of the rules, you misbehaved, you were not sufficiently rehabilitated, you are a threat to the community or society. If that's determined to be the case at a hearing, then the prison officials don't have to release you at the minimum. They can keep you in longer. They would then pick a new date for you to be released, and there'd be a presumption that you'd be released on that new date, unless, again, they determine at a hearing that you continue to commit rule violations, you're a threat, you're not rehabilitated. Under no circumstances, however, can you be kept in beyond the maximum sentence. So even if you misbehaved the whole time you were there, you still have to be released after you've served the maximum sentence, which in this case would be 7 years. I think that covers everything. Mr. Shapiro, is there anything else we need to address or that I've omitted?
No, Your Honor.
Mr. Edwards?
We would thank the court.
All right, thank you.